Hi, very good morning. This is a Delhi High Court judgment. The citation is Deen Dayal Agarwal, HUF versus Capriso Finance Limited. Issues involved are: one, whether civil suit filed without proper board resolution is a valid appeal, is a valid suit or not. Second is whether arbitration clause in agreement will lose the jurisdiction of civil court in the absence of Section 8 application made before the court. The third issue was whether failure to file written statement within the prescribed period can be condoned by the court or not. These were the three issues before the court. Facts of the case: petitioner availed a loan from respondent company under a loan agreement by pledging equity shares of a particular company, say X, in this matter. The petitioner had lot of shares in X company. He went and pledged those shares and took loan. Loan was not repaid. So respondent filed a recovery suit, unfortunately without a proper board resolution. The board resolution authorized the director to file the suit against company X. That is the petitioner was holding shares in that company only. So instead of authorizing the director to file the suit against the petitioner, unfortunately board resolution said the director is authorized to file suit against the company X. So that was the mistake committed by the company, the respondent company. Petitioner filed an application under Order 7, Rule 11 of CPC for rejection of the plaint on the ground that the agreement contained an arbitration clause. So the petitioner contention was agreement contains an arbitration clause. So you are a civil court. The civil court cannot take up this civil suit, and it has to refer the matter to arbitration. But this application was filed under Order 7, Rule 11 of CPC. In the meantime, respondent realized the mistake in the board resolution. Hence, respondent company, they sought permission of the court by way of an application to rectify the defect in the board resolution and ratify the acts of the director who signed the civil suit. Trial court granted permission to rectify the defect, rejected the application of the petitioner filed under Order 7, Rule 11 for rejecting the civil suit filed by the respondent company. And 3, it closed the petitioner's right to file the written statement. This is the order passed by the trial court. So the petitioner filed an appeal against this order before the High Court. So 3 issues were there. One is, because there is an arbitration clause, the court has no jurisdiction and hence it has to refer the matter to arbitration. That was point number 1. Point number 2, suit itself was filed without a proper board resolution. Point number 3, petitioner should be permitted to file a written statement even though there was delay. These were the 3 issues. On arbitration clause, Delhi High Court looked into Section 8 of the Arbitration Act. Then it said the Section 8 says it mandates, in fact, the judicial authority to refer the matter to arbitration if a valid arbitration agreement exists. But this application should be filed before submitting the first statement of the dispute. Point number 1, that is, before submitting the first statement of the dispute. And point number 2, application must be accompanied with the original copy of the agreement or a duly certified copy of the agreement. Supreme Court in Rashtriya Ispat Nigam case held that this power shall be exercised by the judicial authority if the party applies before making the first statement on the substance of the dispute. So that is very, very important. Before you make the first statement of the dispute, you must make an application under Section 8. Delhi High Court said, admittedly in this case, no such application under Section 8 of Arbitration Act was submitted by the petitioner. The petitioner filed only an application under Order 7, Rule 11 of CPC, highlighting the existence of the arbitration clause. Delhi High Court, after perusing Order 7, Rule 11 of CPC, said suit can be rejected only when 1. The plaintiff does not disclose a cause of action. 2. Relief claimed is undervalued and not corrected within the time allowed by the court. 3. Insufficiently stamped and not ratified within the time specified by the court. 4. Barred by any law. 5. Fails to file required copies and the plaintiff fails to comply with the provisions of Order 7, Rule 9 of CPC. Only in these circumstances, court has power to reject the suit. Otherwise, there is no other option. It has to go ahead with the suit. High Court said the petitioner has failed to file an application under Section 8 of the Arbitration Act. The petition under Order 7, Rule 11 cannot be treated as a composite application. You cannot say in an application under Order 7, Rule 11 that there is an arbitration clause, hence you have to refer the parties to arbitration. It cannot be treated as a composite application. If you want, you should file a separate application, which the petitioner unfortunately failed to file. Application under Section 8 has to be filed in a proper manner, within a proper time, and with proper copy of the agreement. And Delhi High Court said this. The Delhi High Court further said, Section 8 of the Arbitration Act does not create any bar to the civil courts. It merely provides an alternative to the defendant against whom a civil suit is initiated to submit to the jurisdiction of the civil court or file an appropriate application under Section 8 of the Arbitration Act for referring the parties to arbitration. The power conferred by Section 8 of the Act cannot be considered as a bar to the civil suit to entertain the application under Order 7, Rule 11 of CPC. Delhi High Court held that in the present case, no application under Section 8 was filed with the petitioner and no prayer was made to refer the matter to the arbitration. Mere existence of arbitration clause by itself would not constitute a ground to reject the plaint. Hence, High Court said there was no illegality in the order of the trial court refusing to reject the plaint. So that was the first one. The second one, as far as the absence of valid board resolution at the time of filing the suit, Delhi High Court said on a reading of Order 6, Rule 14 of CPC, along with Order 29, Rule 1 of CPC, in the absence of any formal letter of authority or power of attorney being executed, the person referred to in Rule 1 of Order 29 of CPC can, by virtue of his office which he holds, he can sign and verify the pleadings on behalf of the company, because Order 29 permits it. Further, a company is a jurisdict entity. It can duly authorize any person to sign the plaint or written statement on its behalf, and this would be a sufficient compliance. Even if there is no board resolution, this is important. Even if there is no board resolution, where the pleadings have been signed by one of its officers, the company can ratify the said action by its officers in signing the pleadings. Delhi High Court said the suit in the present case has been signed by the director of the respondent company. Merely because of the irregularity of the board resolution, the substantive right of the respondent company cannot be defeated, and such irregularity can be cured at any stage of the suit. The mistake in the board resolution filed with the plaintiff is only a procedural irregularity, and therefore the same cannot be made a ground to reject the suit. More so when such a defect is rectified by the subsequent board resolution. The respondent company cannot be non-suited for a mere technical reason which does not go to the root of the matter. Delhi High Court rejected the second contention of the petition also. On delayed filing of written statement, Delhi High Court noted that since the suit was treated as ordinary suit, unamended Order 8 Rule 1 of CPC would be applicable. There, the time prescribed was 90 days time, which was prescribed under Order 8 Rule 1, unamended Order 8 Rule 1. But court said this is only a directory requirement and not a mandatory requirement. In such cases, the trial court can permit delay in filing if sufficient cause is shown by the petitioner. But unfortunately, in this case, the petitioner did not even file a delay continuation petition for filing delayed written submission. Hence, the trial court cannot be faulted for rejecting the request of the petitioner for filing the written statement also. So, Delhi High Court upheld the order of the trial court on all the three counts. Very interesting judgment. Thank you very much. Have a great and wonderful day. Enjoy your Sunday.